chuo cha Nairobi.
Madaktari, walimu na wahandisi,
Mawakili ni wengi na wachoraji ramani.
Chuo Nairobi ni chemichemi ya akili.
Wengi wamefuzu kutoka chuo cha Nairobi.
Madaktari, walimu na wahandisi,
Mawakili ni wengi na wachoraji ramani.
Chuo Nairobi ni chemichemi ya akili.
Kweli
University, twasonga mbele.
cha Nairobi.
University, haturudi nyuma.
Chuo kikuu
University, twasonga mbele.
cha Nairobi.
University, haturudi
Kwa
nyuma.
utafiti tumepiga hatua nyingi.
Afrika wa kwanza kuweka figo kwa binadamu.
Dawa ya korona tunashughulika sana.
Chuo Nairobi ni chemichemi ya akili.
Kwa utafiti tumepiga hatua nyingi.
Afrika wa kwanza kuweka figo kwa binadamu.
Dawa ya korona tunashughulika sana.
Chuo Nairobi ni chemichemi ya akili.
Kweli
University, twasonga mbele.
cha Nairobi.
University, haturudi nyuma.
Chuo kikuu
University, twasonga
cha
mbele.
Nairobi.
University, haturudi nyuma.
Hata kwa kilimo tumepiga hatua nyingi.
Tazama kabete, ng'ombe, kondoo ni wengi.
Shamba la Kibwezi kijani kibichi kwenye jangwa.
Twanyunyiza maji ili kupanda mimea.
Hata kwa kilimo tumepiga hatua nyingi.
Tazama kabete, ng'ombe, kondoo ni wengi.
Shamba la Kibwezi kijani kibichi kwenye jangwa.
Twanyunyiza maji ili kupanda mimea.
Kweli
University, twasonga mbele.
Nairobi.
Mimea.
hata kwa kilimo tumepiga hatua nyingi.
Tazama kabete, ng'ombe, kondoo ni wengi.
Shamba la Kibwezi kijani kibichi kwenye jangwa.
Twanyunyiza maji ili kupanda mimea.
Kweli
University, twasonga mbele.
Nairobi.
University, haturudi nyuma.
Chuo kikuu
University, twasonga mbele.
Nairobi.
University, haturudi nyuma.
Mlango uwazi, wananchi wasome.
Chuo Nairobi tunayo masomo ya ziada.
Malipo ya kiasi mtapata elimu.
Hakuna haja kwenda kusomea ng'ambo.
Mlango uwazi, wananchi wasome.
Chuo Nairobi tunayo masomo ya ziada.
Malipo ya kiasi mtapata elimu.
Hakuna haja kwenda kusomea ng'ambo.
Kweli
University, twasonga mbele.
Nairobi.
University, haturudi nyuma.
Chuo kikuu
University, twasonga mbele.
Nairobi.
University, haturudi nyuma.
Thank you very much. Now I welcome Reverend Oseamitei to take us through the Lord.
Let us pray. Lord God, our Father, in your presence we are gathered this afternoon with hearts full of gratitude for your goodness and love, for the many blessings that you've given to us as University of Nairobi community. We thank you for the opportunities that you give us to make an impact in the world through serving your people, the people that you've given to us. We thank you for our Vice Chancellor. We thank you for our DVCs. We thank you for university management. We thank you for the entire teaching and non-teaching staff and students. And we thank you that you have blessed us in a special way as university community. Even today, as we are gathered to celebrate the gifts that you've given to one of us. Professor Migai Akech, as he shares his lecture, we pray that, dear Lord, the knowledge that he shares and the opportunities that you've given to him to make an impact will serve to inspire us to do our very best in our service to you as we serve humanity and to make this nation great. So as we sit together in your presence, help us to sit and reflect and to fellowship together even as we listen to the presentation. Begin with us, and to the end of it, we'll give thanks through Christ our Lord. Amen.
Sit as I welcome the Deputy Vice Chancellor to give the welcoming remarks.
Thank you very much, Registrar. May I take this opportunity to acknowledge the following. The members of University Council who are here today, the Vice Chancellor of the University of Nairobi, Professor Stephen Kiama, the Deputy Vice Chancellor, Research, Innovation and Enterprise, Professor Margaret Hutchinson, the deans, associate deans, the chairs of departments, our staff and students, family and friends of Professor Migai Akech present here today, members of the judiciary who are here, distinguished guests, ladies and gentlemen, good afternoon. It's with great pleasure that I extend a warm welcome to each and every one of you to the 49th inaugural lecture of the University of Nairobi. Today, we gather here to witness the delivery of a lecture entitled Taming the Tyranny of the Barons, Administrative Law and the Regulations of Power by Professor Migai Akech. Briefly, an inaugural lecture holds a special significance within the academic realm. It marks the acknowledgement of the appointment or promotion of a distinguished member of academic staff through the ranks to the esteemed position of professor. It is a momentous occasion serving as a platform to introduce the professor to both the academic and non-academic communities of our university and the society at large. Furthermore, provides a valuable opportunity for engagement, fostering dialogue and collaboration amongst diverse audience. It symbolizes a pivotal milestone in the academic journey of a professor, allowing them to reflect on past research endeavors while also introducing novel ideas to a wide-ranging audience. The inaugural lecture series serves as a testament to the impactful contribution of our professors towards attaining the University of Nairobi vision of globally competitive university transforming society over the years. It is a platform through which they can showcase their achievements, highlighting the profound difference their teaching, research, innovation, and community engagements has made to the society as large. With these few remarks, now it is my privilege and honor to invite our Vice Chancellor, Professor Stephen Kiama, to introduce today's speaker, Professor Migai Akech, as he embarks on his momentous journey by delivering his inaugural lecture. Welcome, Vice Chancellor.
Maybe before I introduce the chair, I saw the choir was ready to sing. Yeah? Why don't you proceed? Because I saw you ready all through. And then I don't want, yeah. Because you had prepared something, isn't it? Then just proceed and sing, and then I will introduce the speaker. Yeah, please.
Kutoka chuo cha Nairobi,
Madaktari, walimu na wahandisi,
mawakili ni wengi na wachoraji ramani.
chuo Nairobi ni chemichemi ya akili.
Wengi wamefuzu kutoka chuo cha Nairobi,
Madaktari, walimu na wahandisi,
mawakili ni wengi na wachoraji ramani.
chuo Nairobi ni chemichemi ya akili.
Kweli
University, twasonga mbele.
cha Nairobi,
University, haturudi nyuma.
chuo kikuu
University, twasonga mbele.
cha Nairobi.
University, haturudi nyuma.
Utafiti tumepiga hatua nyingi,
Afrika wa kwanza kuweka figo kwa binadamu.
dawa ya korona tunashughulika sana.
Chuo Nairobi ni chemichemi ya akili.
Kwa utafiti tumepiga hatua nyingi,
Afrika wa kwanza kuweka figo kwa binadamu.
dawa ya korona tunashughulika sana.
Chuo Nairobi ni chemichemi ya akili.
Kweli
University, twasonga mbele.
cha Nairobi,
University, haturudi nyuma.
chuo kikuu
University, twasonga mbele.
cha Nairobi.
University, haturudi nyuma.
Hata kwa kilimo tumepiga hatua nyingi,
Tazama kabete, ng'ombe, kondoo ni wengi.
shamba la Kibwezi kijani kibichi kwenye jangwa.
Tunyunyiza maji ili kupanda mimea.
Hata kwa kilimo tumepiga hatua nyingi,
Tazama kabete, ng'ombe, kondoo ni wengi.
shamba la Kibwezi kijani kibichi kwenye jangwa.
Tunyunyiza maji ili kupanda mimea.
Kweli
University, twasonga mbele.
cha Nairobi,
University, haturudi nyuma.
chuo kikuu
University, twasonga mbele.
cha Nairobi.
University, haturudi nyuma.
Mlango uwazi, wananchi wasome.
Chuo Nairobi tunayo masomo ya ziada.
Malipo ya kiasi mtapata elimu.
Hakuna haja kwenda kusomea ng'ambo.
Mlango uwazi, wananchi wasome.
Chuo Nairobi tunayo masomo ya ziada.
Malipo ya kiasi mtapata elimu.
Hakuna haja kwenda kusomea ng'ambo.
Kweli
University, twasonga mbele. University, haturudi nyuma.
Chuo kikuu
University, twasonga mbele.
Nairobi.
University, haturudi nyuma.
So thank you very much, choir. I want to acknowledge all the people who are here, including our main speaker today, Professor Migai Akech. The Deputy Vice Chancellors were here, Professor Hutchinson and Professor Kerubo. The Deans of Faculties, including the Dean of Faculty of Law and the Associate Dean, the family members of Professor Migai Akech, and members of Senate and the students, as well as management. We haven't had inaugural lecture for quite a while, so we are glad that today we are convening here for one. Professor Kerubo has already explained what inaugural lecture is all about. So mine today is really to introduce the speaker for today. Today marks a significant milestone as we come together to honor and celebrate the remarkable achievement of one of our esteemed faculty members, Professor Migai Akech, who has recently been elevated to the prestigious rank of a full professor of the University of Nairobi. Among the many talented individuals we recognized and promoted recently is Professor Akech, who stands out for being the first to present his inaugural lecture. He has shown the fidelity, zeal, and commitment to academic excellence. The inaugural lecture on Taming the Tyranny of the Barons, Administrative Law, and the Regulation of Power presents a unique opportunity for Professor Akech to showcase his profound knowledge in the field of law, share his groundbreaking research, and impart enlightening insights to the public. This lecture promises to shed light on crucial aspects of administrative law and power regulation, reflecting Professor Akech's expertise and passion for legal scholarship. As we gather here today to celebrate the exceptional accomplishment of Professor Migai Akech and his inaugural lecture, I would like to extend a daring challenge to all recently promoted professors to follow suit and share their scientific discoveries, insights, and research findings with the wider academic community. Let us all take inspiration from him and show our commitment to academic excellence. Inaugural lecture not only provides a platform for professor with a rare opportunity to showcase his or her wealth of knowledge beyond the lecture theater to the wider public audience to engage critically with the research presented. I invite all attendees to actively participate, ask thought-provoking questions, and as is deemed necessary, and point out any gaps or areas for further exploration in this area of research. By fostering this culture of academic inquiry, collaboration, and constructive feedback, we can collectively contribute to the advancement of knowledge and the enhancement of our academic community. Let us seize this opportunity to engage, learn, and grow together as we celebrate our elevated faculty. We acknowledge the significance of this event and express our sincere appreciation to the Chancellor and the family of Professor Migai Akech for gracing us with their presence as we initiate him to the Hall of Academy. The Chancellor was joining us, but he was invited to have a meeting with Ban Ki-moon this afternoon, and therefore he dropped out even as we were planning this. I had a meeting just before I came here with him. Let us all embrace the spirit of intellectual curiosity and promote academic excellence. Ladies and gentlemen, allow me to read the citation and introduce our speaker, Professor Migai Akech. Migai Akech was born in January 1972. He attended various schools in Nyeri, Kajira, Muhoroni, and Homa Bay for his primary education. He then proceeded to Starehe Boys Center and the school for his secondary education before joining the University of Nairobi for his undergraduate studies in law. He graduated from the University of Nairobi in 1995 with a first-class honors degree in law, then proceeded to the Cambridge University in the United Kingdom, from which he graduated with a master's degree in commercial law in 1997. He then attended the New York University School of Law, where he was a Hausa Global Scholar, and from which he graduated with a master's degree in trade regulation in 1999 and a Doctor of Juridical Science in 2004. Migai returned to the University of Nairobi in 2004 and dedicated himself to teaching and research. First, the International Forum for Democracy Studies of the National Endowment for Democracy in the United States offered Migai the prestigious Reagan Fasco Democracy Fellowship, which he took up in October 2009 to February 2010. At the NED, Migai research focused on the use of administrative law to constrain government power in Africa, and culminated in the publication of perhaps the article that Migai considered to be his best work, namely, Constraining Government Power in Africa, which was published in the prestigious Journal of Democracy in January 2011. Migai resumed teaching and research at the University of Nairobi thereafter, before proceeding to work for the African Union's Africa Peer Review Mechanism as a governance expert from 2018 to 2020. While at the APRA, Migai monitored and evaluated governance in participating African states and led the development of the African governance reports of the 2019 and 2021. The AGR is the African Union flagship biennial report on the state of governance in Africa. Migai has consulted as an expert on international trade law, policy development, policy analysis, rule of law, governance, devolution, anti-corruption, accountability, policy reforms, justice sector reforms, prosecutorial reforms, legislative reforms, transitional justice, environmental crime, reform of criminal law and procedures, sentencing policy developments, land policy development, curriculum development, monitoring human rights compliance, and mineral policies and regulatory framework for national and international organizations, including the African Union, the African Peer Review Mechanism, the International Development Law Organization, IDLO, the United Nations Economic Commission for Africa, UNECA, the United Nations Office on Drug Crime, UNOC, the Open Society, German Technical Cooperation, the East African Business Council, and the World Bank. He has worked for these organizations in Kenya, Ethiopia, Lesotho, Sierra Leone, Somaliland, South Africa, Sudan, Uganda, and Tanzania. Migai joined the University of Nairobi as an assistant lecturer in 1999, was promoted to the position of lecturer in 2003, senior lecturer in 2006, associate professor in 2011, and professor in 2023. Migai plays football and has chaired the Kenya Premier League's Independent Disciplinary and Complaints Committee. Ladies and gentlemen, please arise and join me in welcoming Professor Migai Akech.
The VC, fellow academics, judges present, government officials present, fellow lawyers and advocates, the media, ladies and gentlemen, friends, family, and all barons present. Good afternoon. Thank you all for the privilege and honor of your presence at this inaugural lecture. I am delighted to deliver this lecture at this historic venue on this day. I have tried, as I usually do, to make the lecture simple. I believe in writing for the broader public, not just for lawyers. And I hope that I'll be able to carry everyone along. And so let me get right to it. My work as an academic has revolved around three concepts, namely power, democracy, and law, particularly administrative law. If there's one thing that has animated me the most, it would be how our daily lives in both public and private spaces are defined by routine and aggravating displays and abuses of power. In these spaces, we typically experience all kinds of tyranny. In our places of work, our homes, social clubs, our encounters with the public and private police, and whenever we deal with bureaucrats in national and international institutions. The irony is that we form these associations and institutions, in many cases out of our own volition, to safeguard our freedoms, by which I mean our liberties and livelihoods. So how then can we retain our inalienable right to self-rule so that we are not oppressed, even if we have agreed to or are deemed to relinquish some of our power or autonomy so that we live in well-ordered society? That is a question that I've spent my life as an academic trying to figure out. I have sought to understand how we can use democracy and administrative law to prevent the abuse of power, so that we can forestall or contain tyranny and thereby preserve our freedoms. My hypothesis has been a simple one. Whenever a person wields a power over you that can affect or affects your liberties and livelihoods, that person has an obligation to exercise that power in a manner that is democratic. By that, I mean that you should participate or have a say in how the power is exercised. And the power holder should be accountable to you in exercising the power. Now, we tend to think of tyranny as predominantly being a problem of governance in the state. And the state, as you know, is the main unit of large-scale governance at the national level. But we do that without scrutinizing why that is the case or how that happens. My contribution to scholarship has been to say that while international geopolitical and neo-colonial factors, for example, development assistance or lopsided international trade regimes, while those neo-colonial factors may certainly account for the tyranny that we experience in the state, bad governance in the smaller units that make up the state significantly contributes to this tyranny. In turn, tyranny in these smaller or subterranean units is enabled by legal grants and sociologies and cultures of power. And so to liberate ourselves from this tyranny, we should therefore worry about and democratize the exercise of power in these smaller units of governance that are controlled by bureaucrats. And it is these bureaucrats that I like to call the barons. And I'm sure there are many present here today. I have tested these hypotheses in various contexts and sought to understand whether and the extent to which the exercise of power is democratic in these smaller units of governance. I have found that the exercise of power is, in many cases, neither participatory nor accountable. And I have to try to explain why this is the case. I have found that governance is often undemocratic and also difficult to democratize for various reasons. I have then demonstrated how we can use administrative law to democratize the exercise of power. But in doing so, I appreciate that the utilization of administrative law is itself shaped by prevailing cultures and sociologies of power. And so in this lecture, I want to share this research that I've done across a period of 25 years. I will proceed as follows. First, I will talk about the concepts of power, democracy, and limited governance. My goal here is to explain why democracy is essential to regulating the exercise of power in collective decision-making processes. Second, I will explain why administrative law provides the tools that can be effective in our efforts to circumscribe or constrain the exercise of power on a day-to-day basis, and why a credible regime of administrative law is a precondition for democratic governance in any context. Number three, I will explain how the barons threaten our freedoms through laws, cultures, and processes of rule-making, rule interpretation, rule application, and adjudication that are autocratic in their orientation. And finally, I'll try to look to the future. I'll conclude by sketching out a future research agenda that consists of examining the opportunities and challenges that the automation of governance, what is also known as algorithmic decision-making, present for democracy and administrative law. As a starting point, we can think of power in terms of our autonomy, by which I mean our inherent right and capacity to govern ourselves as human beings and shape our environments. In turn, our power tends to vary, as you all know, depending on various factors: our resource endowments, our socialization, our literacy, and capacities for group action. From this perspective, power is the ability to make somebody to do something that otherwise he or she would not do. Now, thinking of power in this sense is useful for our understanding how human beings make collective decisions, why some people overpower and dominate others, why others are dominated, and what the dominated need to do to regain and exercise their power. And we therefore need to see power as a social relationship that works to enable the dominance of certain individuals or groups while suppressing the abilities of the dominated to raise their issues and advance their interests in the making of collective decisions. As I explained in the long version of the lecture, power is exercised in both overt and covert ways. In the former scenario, the focus is on the behavior of the powerful and the powerless inside the decision-making arena. This behavior is discernible and can readily be seen for the most part. In the latter scenario, the concern is with behavior outside the decision-making arena, but which affects the actions and inactions of the powerful and the powerless inside the decision-making arena. Such actions and inactions include the prevention of issues from being taken to the decision-making arena. And there are various means of doing that. For example, threats of sanctions, intimidation, co-optation, and manipulation. They also include the control of information, the media, and the processes of education and socialization. And so through these mechanisms, the powerful control the agenda and shape the issues that get to be taken to the decision-making arena and the decisions that get to be made. And so it follows that when we evaluate public participation and other governance processes, we need to look and see beyond the things that happen inside the decision-making arena. When we view power in these terms, we can see that we have a governance predicament. What is this predicament? On the one hand, we claim an inherent right to rule ourselves, self-rule. And that should give us some control over our destinies. But on the other hand, we have no choice but to give up some of our power and live in societies in which, for various reasons, some individuals and groups will always have more power than others. This means that if the powerless are to realize their right to self-rule, they require mechanisms that will enable them to control the exercise of power in the making of collective decisions. Historically, the ideals of democracy and the rule of law have constituted two such mechanisms. Typically, when we use the term democracy, we use it to refer to a system of government in which a group of people who belong to a political organization, for example, a nation state, govern themselves. It is a system of rule by the many and is often distinguished from other forms of government such as monarchy, which is the rule of one person, aristocracy, which is the rule of the best, oligarchy, which is the rule of the few, and kakistocracy, which is the rule of the worst or the least qualified. But seeing democracy as rule by the many is not helpful if we are to regulate power, because, as you all know, majorities can and often oppress minorities. Democracy must therefore mean more than a system of government or majoritarian rule. In addition, seeing democracy as a system of government does not tell us exactly how the people who belong to a political organization govern themselves on a day-to-day basis. How, for example, is power exercised in the making of collective decisions in the many national and international political organizations in which associational life occurs? It is in this respect that I find Robert Dahl's conceptualization of democracy to be particularly helpful. Dahl sees democracy as a process of making collective decisions that requires four unique conditions. The first condition is effective participation, which means that every member of a political organization must have the opportunity to express his or her preferences or interests. The second condition is voting equality at the decisive stage, which means that all votes have equal weight. The third condition is enlightened understanding, meaning that every person knows what is best for him or for her. And the fourth condition is control of the agenda, meaning that the members of the political organization, and not just some of them, collectively have the power to decide what is placed on the agenda of the matters that are to be decided. And so we need to view democracy not just as a system of government, but as this unique process of making collective decisions that facilitates the regulation of power, insofar as it demands the participation of the governed and the accountability to the governed in collective decision-making processes. And so from this perspective, a process of making collective decisions can only be deemed to be democratic if it fulfills those four conditions. And that explains why historically democracy embraced the political philosophy of liberalism, which expresses the idea that people everywhere are created free and equal. They have the right to self-rule, the right to choose their governance, and the right to hold their governors accountable. Liberalism gave us three mechanisms for limiting the power of government. First, liberalism gave us the idea of the rule of law, which is the idea that government is limited by law and every person is equal before the law and should be treated equally. Second, liberalism gave us the idea of a fundamental law or constitution. And third, it gave us the idea of inalienable human rights. Today, these mechanisms are also used to regulate power in the private domain. Today, it is almost axiomatic that in a process of collective decision-making, the interests or grievances of every person who is subject to a political or administrative decision needs to be considered. In addition, the accountability of the rulers to the ruled for their decisions and the exercise of power signifies the primacy or sovereignty of the ruled. Today, we claim to embrace liberal democracy in our governance arrangements, both at the national and the international levels. However, the gap between theory and practice tends to be considerably wide in both cases. And this is what I've tried to study across a period of 25 years. The result is that there's often little or no democracy, given that collective decision-making processes in many cases do not fulfill Dahl's 4 conditions due to power relations that ensure some people dominate others. And so at best, our public participation processes are very, very poor approximations of the 4 conditions. To give you an example that I think should bring this home, our Supreme Court uses standards such as real participation, meaningful participation, deep participation, engagement, and sensitization to assess public participation. The question is, what do these standards mean exactly? And how do we measure them? If you are to create the ideal conditions in which democratic governance can obtain, it therefore becomes important that we figure out the nature of power in any given context, how and why that power is created and sustained, and how and why some people are dominated. For example, what cultures and sociologies of power obtain in any given polity? And what explains these cultures and sociologies of power? Second, what role does law play in the creation and sustenance of power, and why? Third, how can the dominated regain their power of self-rule? And can technology, for example, help the dominated to regain their power of self-rule? Further, how can the dominated use law to regain their power of self-rule? I hope we are together so far. Let me now try to address these questions. At the national level, there is a democracy deficit in our public governance. There is very little meaningful public participation, relatively speaking. And the government is not accountable for the most part. Here, it is a bureaucracy that exercises much of the power of government. When we encounter government, it is a bureaucracy that we interact with. And our interactions with the bureaucracy is often fraught with tyranny that takes many forms, such as delays, broken promises, and extortion. Unfortunately, these bureaucrats are often invisible, given that the mechanisms designed to protect the confidentiality of governmental affairs, for example, state secrecy laws and privacy laws, invariably ensure that they are safely shielded from public scrutiny. The bureaucrats must be tamed if we are to bridge the democracy deficit in our public governance at the national level. There are also democracy deficits in the private domain. Here, globalization and privatization processes have resulted in the transfer of immense power to private entities, which now considerably also affect our freedoms. The recent proliferation of international regulatory mechanisms has also created a democracy deficit in the international arena. Our interactions across borders in domains such as trade and sports have led to a realization that our interests or grievances cannot be addressed by separate national governance systems. And so the result is that the making of these governance decisions has shifted to public and private global institutions, often without our participation or accountability to us. This shift has also created a democracy deficit because these international institutions are not directly subject to control by national governments or domestic legal systems. I'm sure you're asking, so who are these barons? In a nutshell, by the term barons, I mean individuals who possess power in public and private national and international institutions. The barons are everywhere. You will find them in government institutions, the ministries, for example. You'll find them in the public service and its agencies, such as the Public Service Commission. You'll find them in the legislature and its bureaucracy. You'll find them in the judiciary and its bureaucracy. You'll find them in institutions of horizontal accountability. Justice Leilona, good afternoon, welcome. You'll find them in election management bodies. You'll find them in political parties and their regulators. You'll find them in tribunals and other alternative forums for dispute resolution, tax administrators, immigration officers, pensions officers, national health insurance officers, public and private institutions of learning, such as this one, private societies and clubs, local and international sports bodies. FIFA is a good example. The ICC for cricket is another one. You'll find them in the form of international development assistance administrators and many other spaces. And what is it that these barons do? How do they exercise power? The exercise of power by these barons invariably entails some form of rule making. They make rules. They interpret rules. So it is not true that it is only courts that interpret rules. In fact, courts are at the end of the rule interpretation spectrum. They apply rules and they adjudicate or settle disputes that arise from the application of the rules. Increasingly, the barons are also resorting to technologies such as artificial intelligence to make their decisions in ways that are not always democratic. The barons often abuse their powers and are the cause of the tyrannies that we routinely experience in our unavoidable encounters with public and private administration. And so we cannot say that we are free when there is no democracy in the subterranean spaces of life that these barons exercise power in. Fortunately, we can use law in general and administrative law in particular to prevent or manage these tyrannies. Law, because it can be an equalizer of power. Administrative law, because it provides unique tools for circumscribing or constraining the exercise of power on a day-to-day basis. Why administrative law? As the name suggests, administrative law regulates administration. That is the execution of public affairs, contrasted with policy making. Administrative law aims to circumscribe or discipline the exercise of power so that it is not abused, and sanction the barons whenever they abuse their powers. It does so by requiring that the actions and decisions of the barons meet the requirements of legality, meaning that every action must have a basis in law. Reasonableness, meaning that every action must be logical or rational. And procedural fairness, meaning that whenever they make decisions, the affected people must be given a hearing and the person making the decision must not be biased. Administrative law then provides remedies for individuals or groups that are affected by administrative actions and decisions that do not meet these requirements. And by mandating the observation of these requirements, administrative law helps us to constrain human weaknesses such as bias, prejudice, impulsiveness, and corruption. The hope is that the barons will follow these requirements without being policed. And this explains why many established democracies have what are called charters of good administration, which I think is something we in this country should emulate. Accordingly, administrative law, its promise is that it can facilitate the realization of day-to-day democracy by making collective decision-making participatory and accountable. Administrative law also enhances the rule of law by promoting universalism and suppressing particularism. What is universalism? Universalism is the idea that rules or the rule of law matter more than relationships. In other words, we should be treated equally, irrespective of our relations or relationships with the barons. On the other hand, particularism is the idea that relationships matter more than rules, and the barons can favor whoever they like. Administrative law enhances the rule of law by making rules matter more than relationships. For example, in the context of the regulation of industry, it ensures that regulators are not captured by the entities that they regulate through relationships that can make them biased. Again, through procedures such as notice and comment and judicial review, administrative law creates a surrogate political process that enables the interests that are universalistic to participate in the making of collective decisions and to contest such decisions. And for this reason, administrative law gives universalistic interests a voice in collective decision-making processes. And now let me get to practice. Historically, in present times, and the future. Despite this great promise, in practice, the impact of administrative law depends on existing power relations and politics. We should therefore expect that in practice, the use of administrative law will be shaped by cultures and sociologies of power and the willingness and abilities of the powerless to confront these cultures and sociologies. Let me now turn to the practice of administrative law. What explains our practice in terms of administrative law or its use? In Kenya's case, from what I've seen in my research, the use of administrative law has been shaped by a culture and sociology of power whose genesis can be traced to Britain's despotic modes of colonial governance, in which government officials knew what was best for the natives, who were not allowed to question the actions of these barons. Although there were some formal rules that sought to regulate the broad powers of the barons in the colonial state, the barons often context, and so they largely ignored those formal rules. Again, privileged constituencies, such as white settlers and big business, obtained favorable administrative actions and decisions largely through informal channels. Administrative decisions were made in the informal spaces of governance, then later endorsed or rubber-stamped in the formal spaces. Britain therefore bequeathed to Kenya a culture of informalism and authoritarianism, not democracy and the rule of law. Although Britain established a formal system of governance derived from English norms and practices, it governed Kenya using a system in which informal norms dominated the formal ones. The formal legal system featured extremely broad grants of poorly circumscribed discretionary powers, which the colonial administrators deployed without any pretense of accountability. Law unpretentiously constituted an instrument of power and coercion. Further, the functionaries of the colonial system based their actions and decisions on formal rules, informal considerations, or some combination of the two as expediency dictated. This coercive system of governance, which revolved around the unaccountable provincial administration and security apparatus, was retained at independence and gave rise to the imperial presidency. Rosa, good afternoon. This undemocratic system has proved to be intractable. Why? Because the rules of governance continue to be insufficiently institutionalized. What do I mean? These rules are all too often open-ended, and they're neither participatory nor accountable. These rules are a godsend for our governments, which ably use them in overt and covert ways to subvert the progress of democracy and the rule of law. And so we must do much more to circumscribe the powers of the coercive statutory legal order and ensure the day-to-day participation of citizens in governance and accountability of the barons. In this culture of power, the barons are beyond reproach. It does not matter what the formal law says. It does not matter that the Constitution proclaims constitutionalism and requires that the exercise of power should be democratic. It is a culture in which defying the norms of good administration is the norm, and privacy rights trump open government. This culture of power permeates Kenya's system of governance and continues to shape the making of collective decisions and our interactions with power in both the public and the private domains. It is a culture of power that dictates that the president and his minions are the law, and that their decisions must be obeyed and not questioned, irrespective of what the Constitution says. And the police force is socialized to enforce this culture, using vague criminal laws that give them immense discretionary powers. For example, this explains why bail continues to be used as a tool of oppression in our criminal justice system. It is a culture in which power must be displayed, and the barons are omnipresent. In other words, they're present everywhere and omniscient. They're all-knowing. There's a poster that you will find in Christian homes. It goes, Christ is the head of this house, the unseen guests at every meal, and the silent listener to every conversation. These barons are also unseen guests and silent listeners to all conversations. And we also hang their portraits in our homes and places of work. In fact, I think there's one such portrait in this hall. As the examples I have given in the long version of the lecture demonstrate, although we've made great strides in using administrative law to constrain the exercise of power, the application of administrative law continues to be constrained by broad grants of statutory power and the crafty schemes of the barons, who are very skillful at deploying the inherited culture of power to resist democratic governance. In our system of government, as I've said, tyranny is the norm. But this tyranny is often lawful, and it is enabled by open-ended statutory grants of power. In the lecture, I've given various examples. So if you look at statutes that deal with taxation, criminal law, and traffic regulations, you'll see very good examples of this phenomenon. And this makes it exceedingly difficult for the courts to subject this tyranny to the discipline of administrative law. What is the outcome? The barons often do what they want, when they want, and they often get away with it, due to, for example, agenda and thought control. And that is what leads to bureaucratic impunity and corruptions. These statutes enable tiresome bureaucratic microaggressions that are designed to ensure that citizens submit to authority. Fortunately, the Constitution has made it difficult for the barons to get away with their tyranny. Nevertheless, the open-ended grants of power remain all too common in our system of governance, and I'll give you examples. And so they continue to enable the barons to cleverly get away with their bad administration. The pervasiveness of the tyranny also means that the courts cannot do nearly enough to constrain it. And therefore, Parliament and the judiciary need to keep the gates of judicial review wide open as the Constitution intended. They shouldn't be trying to foreclose them as they are now trying to do in the draft Fair Administrative Action Rules of 2024. Let me give you examples of these tyrannies. It is manifested in various ways. For example, a common practice among the barons in the public domain is to invent and deploy subjective, non-prescribed, or irrelevant factors in their decision-making. Another practice is to assume and exercise powers that they've not been given by any law. Let me give you an example. In this institution, the council of this university does not have the power to send a vice-chancellor on compulsory leave. And yet, council does not have that power. And yet, it has assumed and exercised this power on 2 occasions. On what basis? I ask. Yet another practice is that appointment to public offices are not made democratically and are primarily based on considerations of political patronage, as I have often shared with my Vice-Chancellor. In this environment, it is easy for the barons to control the thinking of those that are subject to their power, as the clear message is that they need to toe the line if they want the barons to treat them favorably. In this style of administration, whistleblowers and critics are not appreciated, and their lives often made very difficult through threats or imposition of sanctions. For example, the Employment Act provides that it is gross misconduct for an employee to behave in a manner that is insulting to his employer or a person that is placed in authority over him or by his employer. And so those who are critical of the barons can be branded as disrespectful and even prosecuted for insubordination. Frivolous disciplinary processes will then quickly be instituted against such individuals. And now that on 2 occasions our Vice-Chancellor has defied council, is council going to accuse the Vice-Chancellor of behaving in a manner that is insulting to the employer, namely council? I ask. In addition, individuals who expose the misdeeds or corruption of the barons can be punished under the Official Secrets Act, yet another statute that gives the barons overly vague and broad discretionary powers. The result is that there is little or no protection for whistleblowers. And as you know, efforts to pass a law in this respect so far have all floundered. Again, this encourages impunity and tyranny, as many abuses of power are not challenged. Above all, this culture of power means that administrative law actions are bound to be episodic. As you've seen, the barons are everywhere, and they abuse their powers everywhere. The courts cannot deal with it. Their tyranny is pervasive. And as we know as well, a person that wants to file an action in court often encounters very many systemic barriers. And in the long version of the lecture, I discuss how these dynamics play out in various contexts of national public administration. Those examples are only illustrative. As I have indicated, the barons are ubiquitous. The tyrannies that I've illustrated in the lecture, they are replicated in very many other spaces of our lives. And now that I practice law, I think the problem is much worse than I thought. And the examples that I've given demonstrate the tyrannies that citizens routinely encounter in their dealings with the barons. And these tyrannies are replicated in the private domain. For example, there is pervasive tyranny in the case of international bodies, including sports organizations such as the International Cricket Council and the International Association of Federation Football, FIFA. I've given you examples of how this works out in the long lecture. These organizations largely operate outside the purview of national and international law. International geopolitical and neocolonial factors such as development assistance and lopsided international trade regimes, as I've said, also contribute to the tyrannies that we experience inside the state in our national governance systems. In the case of development assistance, for example, and I've studied public procurement regimes that use this model. In this case, the development partners give us aid using laws and institutional mechanisms that bypass public accountability systems. In fact, our public procurement regime legalizes this tyranny by exempting from its application the procurement that is made under bilateral or multilateral agreements. The recent oil supply agreement between our government and the oil exporters from the Gulf is a perfect illustration of this tyranny. What all this means is that we experience pervasive and democratic governance in our associational life, in the national and international domains. So the question is, how do we make governance more democratic in these spaces? There are a number of things that we need to do. One, we need to pay greater attention to reforming our statutory law regime so that it can confer less discretionary powers to administrators. This is a work that the Commission on the Implementation of the Constitution was supposed to do. It did not do that work. The result is that we left the reform of those laws to the vagaries of constitutional litigation and judicial review. In this approach, we have asked the courts to strike down the statutes for being unconstitutional. The courts have obliged, but only in a few cases, relatively speaking. We have over 1,000 laws and regulations. If you're going to leave it to the courts, that people file court cases, that we wait for the courts to say these laws are unconstitutional, it will take a very long time. The tyranny will continue. And so, this approach has ensured that the vast majority of the statutes remain intact, and so remain instruments that the barons use to oppress citizens. And to make matters worse, we continue to use the same colonial approach to drafting laws and regulations, which entails giving the barons overly wide discretionary powers. Perfect examples are the Draft Fair Administrative Action Rules of 2024 and the Traffic Act. Look at the Traffic Act, for example. It gives an inspector the power to remove someone's vehicle's identification plates without due process. A police officer or an inspector can just decide that you've committed whatever offense, and they will take the plate. No due process. This needs to change. We must always ask ourselves when we draft these laws, and I'm talking to lawyers, the drafters. We have to ask ourselves, are the powers that we are giving these barons necessary? Are these powers the least restrictive means available for achieving their regulatory objectives? So that is number one. Number two, we need to enhance the supply of good administration and the demand for democratic governance. Good administration would mean that the barons do the right thing in the first place in making their decisions or taking actions without being prompted and without being policed. One way to do that is to formulate and implement a national charter on good administration. A charter like that one would encourage the barons to make decisions that are motivated by what is right, not by avoiding punishment for breaking rules. Because that is our approach. You see very many instances where the barons weigh and say, well, let's just do it. Let's see what the courts do. By the time the courts act, we'll have achieved our political or whatever it is, bureaucratic purpose. And that's the wrong approach. In addition, as you can imagine, supplying good administration in a society such as ours, in which political patronage and corruption are pervasive, is bound to be a difficult task. The method we've adopted in the Constitution for selecting public and state officers is clearly not working, and we need to rethink it if we are to ensure that we select those officers on the basis of merit. And because the method for appointing these officers is not working, the risk is that we will become a kakistocracy. Third, and on the demand side, we need to empower our citizens so that they make better use of administrative law, including and training them to challenge power. Again, a national charter on good administration could enhance the demand for good administration. In short, a national charter on good administration would enable us to socialize the barons and citizens differently when it comes to the exercise of power. I believe this is the only way by which we can change the culture and sociology of tyranny in our administration. Fourth, we need to deal with the informalism in our governance system. For sure, we can expect that some level of informalism will always be prevalent in any governance or political system. After all, politics is about negotiation. But that kind of formalism and the negotiations that go with it needs to be kept transparent and open to public scrutiny. One way we can do that is to enact a law that, as a general rule, the meetings of the barons should be open to public observation. These meetings should be publicized. There should be records of these meetings, and the public should have access to these meetings. So that we don't have a situation where, for example, the judiciary is meeting in secret with the executive. Finally, and I'm addressing the Supreme Court. The Supreme Court needs to revisit the guidelines for public participation that it established in the BAT case. I think we can formulate clear guidelines along the lines of Dahl's 4 conditions of democracy. Because let's face it, the kinds of public participation or processes that we claim that the public have participated in this country, they're a sham. And so we have many false positives and we have very many false negatives as well. So the court must demand much more from public participation initiatives. One way of doing that is to establish indicators of public participation that factor power dynamics and address what happens inside and outside the decision-making arena. Surely, can anybody really say that there was public participation, for example, in the BBI process? It is only through such an approach, I believe, that the courts can equalize power in public participation processes. And lastly, the courts also need to be more inclined to subject the exercise of private power to the discipline of administrative law. And I've looked at various cases coming from the courts, cases involving, for example, the Kenya Association of Music Producers or FIFA. What they demonstrate is that invariably our courts have abetted the tyrannies of these entities. Again, these needs to change. Let me now try to look ahead, and I am getting towards the end of the lecture. A future research agenda. Given human weaknesses such as bias, prejudice, impulsiveness, and corruption, it would seem that attaining the rule of law in our systems of governance is an impossibility. It would seem that achieving universalism is always going to be a pipe dream, as long as human beings control administrative decision-making. In addition, as we've seen, challenging unfair administrative action is often a very difficult or daunting task for the powerless. Constraints dictated by existing cultures and sociologies of power also mean that we won't always succeed in our efforts to question unfair administrative action. So, why don't we use machines? Let's get human beings out of the equation. Let machines make decisions for us. Perhaps using machines or algorithms to make or assist us to make administrative decisions will save us from human tyranny and help us to attain the universalism that remains elusive. And this is personal for me. In the case of my long-delayed promotion to full professor at this university, yes, I was going to talk about it. Perhaps I would have been treated better had the decision been left to an algorithm. Certainly, an algorithm would have quickly determined whether or not I had met the promotion criteria. And certainly, it would not have taken 6 years. And so, why not algorithms? Algorithms can be used in decision-making in two ways. First, we can use them as aids to human decision-making. Number two, we can use them to make decisions, removing human beings from the equation, eliminating human discretion altogether. In either case, their uses may cause harms that implicate administrative law. And so as I look to the future of administrative law scholarship, therefore seems to me that we need to grapple with what the technologies that enable the digital automation of governance portend for democracy, the rule of law, and the exercise of power in the various contexts of public and private administration. This automation is powered by machine learning algorithms, which constitutes a facet of artificial intelligence, and have created what is now termed algorithmic decision-making or automated decision-making. Algorithmic decision-making raises a number of questions from the perspective of administrative law that should now concern scholars. What I've done in this part really, for those that are scholars, is really a literature review. This is how I like to do my literature review, trying to look to the future, figure out what kinds of research questions we need to address as administrative law scholars. So what are these questions? The primary question: will these technologies help us to tame the tyranny of the barons? Or will they make matters worse? Will the use of these technologies be beneficial in the sense of promoting fairness and universalism in decision-making? Or will they exhibit the very same human biases in decision-making that undermine our freedoms? And should they do that? Should they exhibit the same human biases? Will administrative law as we know it today be able to deal with these problems? Or will it require new tools that are suited to this fourth industrial revolution that is unfolding? In other words, should algorithmic accountability regimes sit on the same foundation as the due process artifacts of the industrial age? And what do these technologies portend for existing power relations? Will the technologies be an equalizer, or will they merely serve to reinforce existing power imbalances? As I conclude, I hope I've not been too long. It seems to me that administrative law will cope just fine with algorithmic decision making, even if its principles and procedures will require some adaptation or contextualization. The safeguards of administrative law can no doubt help us to manage algorithmic decision making. However, much will depend on how we implement them on the ground and the politics of the ground. In the coming years, therefore, I plan to study and contribute to policy discourses on the application of administrative law to algorithmic decision-making and the automation of governance. They say that the successful academic is the one who is able to exaggerate the importance of his or her work. I hope that I have succeeded in exaggerating the importance of my work. Ladies and gentlemen, thank you for your kind attention, and please just give me a minute. There are people that I must appreciate historically. My mom, who is here, and it is my mom who first taught me about the barons. My mom distinguishes governance in two sets. She talks of Sirkal Maber, which is good governance, and Sirkal Mager, which is bad governance. And that is how, when I was growing up, she used to describe her bosses. My mother worked for the police division in Homa Bay town. I want to recognize Professor J.B. Ojwang. I would not be an academic without J.B. Ojwang. Who for me is the epitome of academic cool. Gilbert Arum, I don't know if Gilbert Arum is here, who taught me to look beyond law. Professor Frank Upham at NYU, the university whose gown I proudly wear today because that is where I became an academic. Professor Bill Nelson, it is Bill Nelson who taught me how to write. Justice Lenaola, who's offered me wise counsel for many years and has been a tremendous friend. Justice William Ouko also offered me tremendous counsel. Dr. Mutuma Rutere, who's also here today. Whenever I have work and I want an unlegal perspective on that work, I usually turn to Dr. Rutere, and he very graciously read the long version of the inaugural lecture and gave me tremendous feedback. If you see the lecture, you'll see that I have acknowledged Dr. Rutere. Thank you, Mutuma. Professor Kwasi Prempe, a colleague that I met in the US, a Ghanaian, who also read the inaugural lecture and gave me tremendous wisdom. It is him who told me, but you must tell them who these barons are. Apo Lomboya, my lawyer who's helped me to fight the barons at this university. My good friend Evans Ogada, and former student and colleague in the law firm. Evans, where are you? Please stand up. My good friend Evans Ondieki, when I decided to go back to practice, I approached a number of practicing lawyers, and Evans Ondieki very readily took my hand. And so if you see me often, you'll see me in court with Evans. Here is Evans Ondieki. He's the only person that I call Mheshimiwa, because I think he really truly is a Mheshimiwa. Laura Nyirinkindi, who's not here but introduced me to the world of the African Union. Dr. Rose Mwebaza, who works for the United Nations and introduced me to the world of international consulting. Dr. Mark Matunga, who's a tremendous friend, my client, and the most optimistic individual that I know. Mark is not here. Bishop Jen Kirima, who always has very kind words of wisdom, and my client as well. The Vice Chancellor, Professor Kiama. I know I give you a hard time, but it's usually for a good cause. Mr. Webuye, the academic registrar, and his team, this event would not have been possible without the tremendous work that the academic registrar and his team, corporate affairs, Brian, who's standing there, did. And my students of administrative law, including Roslyn Jogu, whom I like to call Rosa. Rosa quite possibly is one of the, if not the best student that I had the privilege of teaching. Thank you, ladies and gentlemen.
Yeah, you have convinced us that that's a good display. Yeah. But now it's a time to interact with him and ask him questions. We will take a couple of questions, maybe 3, 4. He answers those, and then we pick another like that in a series. When you are ready, then I will begin the process. Yeah. I will first start with mine, just a short one, just to find out. There's quite the changing, the change in the registration is so fast after the 2010 Constitution. Yeah, they are so, including the Fair Administrative Act and very many, but there are so many laws which have come about. But we still, people do not read as much. Yeah, so they still operate in an old dispensation of the balance that you are referring to. Because that's what they were used to, that's what they know. Yeah. What is it that can be done to bring as many people as possible on board? Because I trained in Switzerland myself, and I know how they have downplayed that role of the balance. Yeah. That even if you want even a road to pass through somewhere, people must vote. If you want to be a citizen, the community where you live must also participate. Yeah. They have gone to that extent. But here, everybody just says, does it the way it was done by Kanu, yeah, for example. Yeah. So what is it we can do to get everybody on board there, so that we slow down or reduce the barons in our midst? Yeah. So I think that's my question, but let me hear the other questions. I see Uta there and see, yes, we sit with you from front and then we go like that. Let's start with the one first row, yeah, second row like that, yeah.
Thank you very much indeed, Vice Chancellor. I want to ask my good friend maybe a comment or a question. And thank you for reminding us that we need to give our inaugural lectures. I was a little anxious about your entire theorization of the performance of power, which I felt was taking me back to the intellectual tradition of the 70s. That Ngugi really popularized when we were students here. Them and us. The them and us, which some people these days call the single binary concept of power. I don't know what your thoughts are, because the exercise and performance of power is getting a lot more complex with those people that you are calling the oppressed, actually sometimes exercising their own power, even through silence. So I would have expected a more nuanced theorization of the same, so that we do not imagine that power is only exercised by certain people who are on top. If you get my point. Thank you.
Yes.
Thank you, Prof, and thank you very much for the riveting lecture. I really enjoyed it. I want to ask 2 quick questions. The first one is, I really enjoyed the motif of the Baron and what you've done with the Baron in helping us understand who's holding power and who is acting. Are you able to extend that motif to private spaces beyond the ones you've described, such as the family? So I see you've moved to the market, for example, and we've talked about private actors. But are you able to extend that motif to even more private spaces, such as the family? And if we think about the family, who then, in that case, might be the Baron, and how does the Baron in that space act? What could be the technologies or the cultures or the mechanisms for dealing with the tyranny of the Baron in those very private spaces? My second question is around what you proposed as a national charter on good administration. I realize that these days in my role as principal secretary, I might be the Baron, and that might be the reason you are smiling at me as you made the lecture. But how would a national charter for on good administration differ, say, from other pieces of work, such as the principles of public service and national values that already exist? And how would a charter, which, as I understand it, maybe a document, interrupt these cultures and these sociologies of power that you've spoken about that have been created over the years? So in my view, it looks like you're using a formal tool to deal with a culture of informality. How would that work? And if you allow a very quick third one, as you go into the next phase and think about AI, automation, and so on, these technologies that we hope will give us a more fair administration of justice or whatever, how can we think about, or are we worried, and as scholars like yourself, should we be worried about these technologies introducing new areas or new spheres of exclusion, new spheres of entrenching things the same way? Will AI ultimately become the Sirkal Mager? Thank you.
Okay, thank you very much. We go to second law there. Yeah.
Thank you. Thank you.
Yeah.
Thank you. My name is Dr. Kengov. I'm a physicist. I have 2 very brief questions. Number 1, you talked about the unseen barons, the unseen ones. I'm not going to ask about the ones you can see. At least those ones, maybe there are ways to deal with them. The unseen ones, you talked about them yielding a lot of power. How do we deal with these practical ways of dealing with these unseen barons? The second question, you talked about the delay in your promotion, 6 years. I believe that probably you are associating this with barons in the university. Are you associating this with barons in the university? You are 6 years. What did you do? Thank you.
Go ahead.
Thank you. Prof, 3 small questions, but before that, Professor Kiama, thank you so much for allowing the choir to sing, because our music is very integral to African culture and African ways of doing things. Without music, the world would be a very sorry place to live in. And there is no ceremony in Africa that can qualify to be a ceremony without music. So thank you very much. Yeah, Prof. Akech, very interesting lecture and very eye-opening. 3 small questions. One is democracy universal? Because implicit in your engagement with the meaning of the word democracy actually indicated that. But I was wondering, what then do we do with fairly relative socio-cultural constructs which obtain in situations where democracy operates, if we assume that it is universal? Now, my second question is with your use of the concept baron, which is actually very British, which means the British nobility, what they call the lords. Now, I struggled with that quite a bit because I found it very overly Anglophile. I understand, of course, that the University of Cambridge is your alma mater. That's something we share. I don't know which college were you. I was in Fitzwilliam. But then, you know, the use of the term baron, which is overly British, you know, overtly bespeaks of linguistic dependence and negates what Professor Ngui Wathiongo called moving the center. Couldn't you get any alternatives? My last question is, you'll agree with me that inaugural lectures are closely related to the old adage of love for knowledge, pursuing knowledge for the sake of knowledge. How do we deal with the current world, you know, where funding bodies, where governments are increasingly measuring what we do in the academy, you know, in terms of quantity and impact, which is far removed from the tradition that is associated with, you know, inaugural lectures. We are inaugurating you as a professor today just to pursue knowledge for the sake of it. And my second bit of that question is, why are you pursuing knowledge? Thank you.
Thank you very much. Now, I'll respond to those ones, then we go to another series of questions. Please, Professor Migai Akech. Yeah.
This thing has static, eh? Thank you all for the questions. The Vice Chancellor. Yes, so you see, we fundamentally have a problem in this country. Is that for longer than Kenya has existed as an independent state, what we've known as law is in the statutory order, not the constitutional order. And so power, real power lies in the statutory order, not in the constitutional order. In fact, it was not until the 1950s that the colonial administration came up with a constitution. I don't know if it was called the Lennox Boyd, I don't know which, I forget which one was the first one. But that was almost 50 years up from the inception of colonialism. So you have sets, a culture, a sociology in terms of how things work. And then come independence, and then we decide we will just take everything lock, stock, and barrel. Nothing changes. Look at what we did with the provincial administration in the Constitution. The people wanted us to get rid of it, but it remains to date. It is exceedingly intractable because that is how power is exercised. You remove the provincial administration, you'll have a totally different terrain of power. And so our mindset is that of the old order, not these lofty ideals in which we see the Constitution. That is why somebody can decide somewhere that I am going to exercise powers that I know very well are not given to me by any law. Why? And they will get away with it. Why do they do that? And the only way, therefore, to bring people on board to the new dispensation is a process of socialization. That is different. And that is why, for me, this National Charter of Good Administration is a way to do it. Because we need to ask ourselves. We give our power, and I'm trying to address what Professor Ota was saying as well. I'm not looking at power in a binary sense. I'm saying that, first of all, we have power. But we encounter other people that have more power than us. Even as a collective, we'll have power. But how do we exercise that power? How do the power dynamics play out in any polity? Why do people get dominated? Why is it that some ideas are suppressed and others are carried forward? How do these things play out? And if we recognize, first of all, that as human beings, we have the right to self-rule, how do we express very deliberate, and it is very colonial. It's a very British thing. How do we get out of that mindset so that people even know that, look, I can challenge these powers? So I don't think I'm looking at power in that sense. Huh? Rosa, thank you. So as you've seen, in my work, as you're familiar, you remember the Odumbe case, which we did together. Yes, there are these democracy deficits in the private domain as well. And why it exists is, again, if you look at it from a liberal theory perspective, the tendency was to assume that our concern should only be with regulating the public sphere, not the private sphere. That leave the private sphere inviolable almost. But as you know, as you and I know, all these tyrannies there probably was in those contexts, private contexts that are hidden. And that is why this whole movement of the horizontal application of constitutional norms. So that we just don't say that, the body, in terms of the exercise of power that threatens our liberties, is in a vertical relationship with us, is the state. It is also among ourselves. I'm sure if you looked at the many governance regimes in the public space, whether it is a family or it is private companies, you'll come across the same tyrannies. And yes, the national charter would be very different from the principles of public service, for example. What I'm envisaging is a charter that articulates Article 47 of the Constitution. Every person is entitled to administrative action that is lawful, reasonable, and procedurally fair. What does that mean from the perspective of an administrator who is about to make a decision? How should they act? What should they do? Countries such as Australia have done this very well, and I think we can learn from them. And also the citizen, what should the citizen expect? Because part of the problem with us as citizens is that we are very cowed in front of administration. Whenever we see a bureaucrat, the first thing we'll call them is Your Excellency, Mheshimiwa, and such terms. When we do that, already the equation is in their favor. You are on the receiving end. I think that needs to change. Yes, the danger is that technologies will either work for us or not work for us. And the problem with algorithms is who's making them. Is the making of these algorithms democratic, for example? Are they transparent so that they tell us their methodologies? Because a lot of the time, algorithms suffer from what are known as black boxes. You put something in, what comes out, you have no idea. And that may actually propel the tyrannies. But on the other hand, there are many things in this country, bureaucratic processes, and the one that I've studied is pensions. A lot of people suffer over small things that if we automated, For example, the processing of pension. Somebody doesn't have to travel, a retired public servant doesn't have to travel from their village to come to Nairobi to get their pension. And a lot of it is deliberate. The bureaucrats, the barons are very deliberate, so that you pay a bribe, and that is the only way you will get your pay. Ogengo, the unseen barons. When I use the term unseen, invisible, what I mean is that it is seemingly so, because we do not pay attention. When we think of governance or democracy in our context, we are thinking usually in the context of elections. We are not thinking in terms of where I work, how am I treated? Am I consulted in decision making? When the council of this university decides that it is going to create new administrative positions that do not exist in any statute, where do they get that power? And who have they consulted? As a senior academic, have they come and asked for my opinion? They haven't, for example. Those are the people that I call the barons. Is democracy universal? I believe it is. Amartya Sen has written a very good book on this subject. I would invite you to read it. Because I believe that every person wants to be treated fairly. Every person wants to be consulted when decisions that concern them, that affect their liberties and livelihoods, are made. And every person wants whoever is making a decision over them to be accountable to them. So if you define democracy in that sense, then I believe it is a universal value. Obviously, there'll be various social or cultural nuances, but fundamentally, I think those are things that we all as human beings hold dear. Is the term Baron British? Yes, it is, and I use it very deliberately. And that is exactly what I wanted to convey. Because these barons behave like English lords. That is the point I was trying to convey. How do we deal with a world where the focus is on measuring and the impact of academic work? I think we need to return the academy to the academics. And number two, by returning the academy to the academics, I think it is in terms of putting academics at the forefront in terms of management. If you look at the design of our governance framework for universities in this country, I think it is wrong. Because what it says is that somebody somewhere has established a council. This council makes all the policy decisions in the university. And then the people that are the core of the university, the academics, are confined to figuring out what should be the size of the gown, what kind of programs should we have. So we are confined to what are called academic matters. We are not at the forefront in terms of the governance processes. That, I think, is entirely wrong. The academy is an academy of scholars. The Senate, for me, should be a body of scholars that make policy decisions for these universities. I suppose the reasoning behind giving council policy decisions is that we do not fund our public universities. They are funded by whoever is appointing these councils. And that leads me to the second question. The second answer, if we truly value academic work, then we must fund it. It is tough, I can assure you. It is extremely tough being an academic in our environment. In fact, sometimes you'd think, I've asked myself often, why did I do this? Why did I spend 25 years? Why have I spent 25 years of my time doing this work that does not give me much income? I still don't know. Why am I pursuing knowledge? I don't know. I think you get drawn. The academy has a very strong pull. There's nothing that has pulled me or excited me as much as academic work. I love it. I'm not too sure about the context in which I work, but I love it.
Thank you very much. We will go to another series of questions. I will ask John Orindi to conduct the next series of questions. John Orindi, please. Yeah.
Thank you very much, Vice Chancellor. You already have a microphone. Your name and the question.
It's all working. Yeah, first of all, thank you very much, Prof. I had to fight barons here to get this mic. So this is very, very reflective. But I want to attack a little bit of what you posit. And it is funny because I love barons. And I move around them and I love everything about them. But is that not the same case for all of us? Because our DNA is that we are born innately with sin, with imperfections. And there are things that draw us towards the space where barons are. And that before we think about administrative law, in fact, our DNA has already formed administrative boundaries. That when you are born, before you come to the formal space where you meet the administrative law and the statute, that you are born in an environment where you are fighting resources, you're looking for water, food, shelter, and already you've begun to show some signs of barrenness in your life. All of us, with the exception of none. But then we move to the discourse where we meet the construct of administrative law that again has a DNA. The first DNA is the one that is on statute, which is the formal analysis. The second one is the interpretation, which is the expression, and those who at least hold or enforce administrative law, because administrative law cannot be enforced outside the letter of the law. It has to have someone, a person. Even if it is artificial intelligence, somebody must be behind the computer to instruct the computer. So then my question is that in addressing the asymmetry or the problems of administrative law, should we then go back to the theory of Lenin and Stalin, if I can use that parallel, to say that these systems will form themselves, collapse, reform again, and metamorphosize on their own life cycle without too much constraints that make them too artificial to operate? And that is the realm of my question, that in bringing artificial perspective to it, will we be then trying to re-engineer the DNA, which again will not give us the results that we want in the long term? Thank you very much.
Another lecture.
John,
Yeah.
I think I already have the mic.
Oh, sorry. Let him go then you.
Yes, thank you very much. My name is Maloba Wekesa. I think I'm among the few people, Professor, that we debated this inaugural lecture. I was quite privileged to actually debate it with you in person before it was presented here today. And you remember what I told you, that for me, my definition of what democracy is very platonic. A charming form of government that is full of variety and disorder, but it is dispensing justice across those who are equal and those who are unequal evenly. And you remember what I also told you. Even as we are doing that, we need to move from theory to practice. And your acknowledgement at that time was that to move to practice means that we have to do away with the impediments, which your lecture has actually acknowledged are quite phenomenal. How then does this lecture, at the end of the day, and your mom is sitting here, I want you to promise her that what you have actually said is actually going to move. is actually going to move to practice, because that is the enormity of academicians. We theorize a lot, but then at the end of the day, how do we make sure that it is actually in practice? Thank you very much.
Yes, congratulations, Professor, for tackling the vexing question of good governance. I have 3 short questions for you. Number 1 is whether the University of Nairobi, in collaboration with the various departments, can come up with guidelines to regulate the ethics of artificial intelligence. Because that's an area that is new, but it has no regulation, it has no guidelines. Number 2, what is the role of academic institutions in terms of reducing ethnicity to achieve good governance in terms of the power play you have already discussed? And number 3, what collaboration can the university engage with the private actors, non-state actors, to ensure that good governance is achieved both at national and county levels?
Yes.
Thank you very much. My name is Wanjiru Gekonyo, and I come from the civil society sector. And Prof, I'm very happy to have been here for this speech. I reached out to you when I found a short version of your book on the privatization subject online. I read the short version. Listening to you, I need to read the full book because that's a 2015. I think you're building upon very important discussions that you brought out in 2015 and taking it forward. The point I'm making, and I think I want to echo this, the question around what needs to be done. Academia needs to work with the civil society, with the advocates, so that this message can go out. In fact, this inaugural speech, needs to be heard by many others. And as you were speaking, I wondered what happened to Nairobi University. I expected that the hall would be full and spilling over. Was it the mobilization? Did the students not know? Because this is a very important message. I feel this is a seminal message that touches on so many issues, not just the law, the socialization, and those barriers that are holding us back. So really, it's to congratulate you and to say the point of practice is partnerships and collaborations that are founded in advocacy. And maybe the last point is that universities, maybe because of the structure, let go of advocacy. And as they've done that, we are now seeing the privatization push that is really killing the public universities. Really, we don't have the luxury of keeping quiet in any sector. All people of goodwill who want to support democratic governance must embrace advocacy. It's not just private universities that are struggling with funding, so do civil society. So the point is we have a common cause for the soul of our country, for our democratic governance. So those collaborations are important, and a spirit of advocacy at all times. Thank you.
We do one more or two more, Prof? Two more. So you, then Professor Ongore.
Professor Migai, thank you. Bellissimo, crisp, neat. I don't need to exalt your credentials. If anybody wanted to know the mix of theory and practice as a result of your work, then they need to look at me. I go to court, we defend the Constitution, we stand for it boldly in the language of Akech Migai. Now, Professor, the Baron sphere, national security and foreign policy. This has been a difficult area, and it's heavily laden in common law paranoia that you're told this is a sphere beyond judicial review. How do we deal with this? Because it's an area where we have a lot of problems, and the barons have deeply enmeshed their claws. They don't want to cede to public scrutiny and certainly to judicial review. Thank you.
Good evening, Prof. My name is Vincent Ongore. I'm an associate professor at the Technical University of Kenya, where I teach corporate governance. I've actually never met, I actually met you once at the airport in Kisumu, and we had a short talk, but I'm very impressed. And it's on the basis of your latter comments towards the end that I want to say something. What I get from your inaugural lecture is that you are telling us the process of creating social contract must be based on what I call minimum ethical consent, which is legitimacy. And legitimacy in creating the barons. In other words, creating barons must go through a legitimate process. Now, if that is done, then their actions will achieve what we call minimum ethical or minimum moral consent. Now, and what is minimum ethical consent supposed to do? To ensure accountability and also to minimize the joyrider effect, where the majority of the people who are affected by decisions do not participate at the table as decision makers. Now, you are telling us, and I agree with you, that we should use the law as a tool to remedy this imbalance. But who makes the law? The law is made by the elite that either has self-interest or is part of the wider group that hopes to have, some dividends at the end of, when that law comes to fruition. And therefore, this is a conundrum for us. But moving forward, so that I let others talk, I'm very impressed by your proposal on the use of machine learning capability to solve some of our problems. I'm not a lawyer myself, but my friend here tells me that in the whole spectrum of making a judgment, there are facts, there are circumstances, there are rulings, and then there are judgments. But now, if we are using this process to create algorithms in a process that is not watertight, and we know that garbage in, garbage out. So what is it that we expect at the end? And finally, we have countries, and I've lived in some of them, that have managed to tame this marauding animal. I'm saying that I've lived in some countries that have managed to tame the barons, just to ensure that they make decisions that benefit the majority of the people, so that the delineation between the barons and the joyriders is then blurred. So what is it that they have done, and why don't we do it? Why should that require a whole professor when there's already something established? Why are we trying to reinvent the wheel? Thank you.
Dr. Wekesa. Let me start with Desmond. In the teaching of, I wish Pielo Lumumba was here today. Pielo used to tell us, Pielo Lumumba taught me administrative law, I believe 1992 or 1993. And in introducing the subject, he used to say, even God gave Adam and Eve a hearing before he condemned them. He removed from the garden. So, yes, we are born with imperfections, but I think the idea that we should be treated with fairness is something that is with us throughout humanity. And because of power differentials, I don't think you can expect that systems will form and reform without interventions, because those systems also embody power relations. In ours, a system of government imposed by a colonizer, I think itself embodies some unfairness that we should not accept. And law itself is an equalizer. You know, we use the scale as a symbol of law because that's precisely what it should be doing, to equalize powers so that there's fairness. And it's the only way, if the law is about enhancing the dignity of everyone, that is the only way that we can do it. There's a book that I love by Don Oliver. It's called The Common Values in Public and Private Law. Law is about fundamentally protecting our dignity as human beings, whichever way you look at it. Dr. Malobo Wekesa. And my apologies, I forgot. Dr. Wekesa is our champion in terms of the union. In my battles with the barons in this university, I would not have gotten anywhere were it not for the kindness of Dr. Wekesa. I didn't know him before. We only met when I started fighting, when these battles found me and I figured we needed to fight them. So thank you, Dr. Wekesa. And thank you also for the conversation we had about this lecture. That was in January, February. Thank you. Now, as I told you, I like to be practical. And that's why I was proposing a number of things. And I've tried to do this work practically as well. So for example, I helped the judiciary develop its bail and bond guidelines so that there is more fairness in the administration of bail. But like I'm saying, if you're to look at it, and I think Evans Ondieki and Wanjiru as well were asking, if you look at what I'm saying we need to do, I think the concept of a charter of good administration is something that we can all collaborate on, as the academy, as a civil society, and as government, because it will help us govern ourselves better in whatever spaces we look at it. Just to give another practical example, in terms of how we draft law, when we teach our students, imagine the many generations of lawyers that I have, for example, taught in 25 years. If I teach them, and hopefully they hear, that please, when you're called upon to draft a law, ask yourself, is the power that I'm creating in this law necessary? Also, when we know that we have oppressive laws in our statutes, why should we wait for the courts to overturn them? Why can't we have a program by which we identify these laws? I've given you a good example, the Traffic Act, Section 106. And Section 106 is a recent addition. Usually when you see a statute, there are section, they have indicated 6A, B, C, it means it was amended. Why in this, the Traffic Act was enacted in the colonial era. And then when we amend it, we make things worse. Why are we doing this? Why can't we ask ourselves, is this power really necessary? In our kind of context, how is this power going to be used? How, as an inspector, I have given the power to remove a plate, a vehicle's plate. How is this person going to use this power? Is this the least restrictive means of doing this? How terribly inconveniencing for a citizen who's on the receiving end of a law such as that. And then for our Supreme Court, this whole idea of public participation. It is the most litigated issue in our Constitution. But we are not clear when we are saying public participation. You can't really say that, look, we can predict that case 1 will be decided, we will know there was public participation or not in the same way that we will treat case 2. There is no predictability. Again, if we use the indicators approach, which is basically what I am suggesting. Can we have a process by which we say that these are the indicators of public participation? There's been a process of enacting a law on public participation. It's not been passed yet. Why don't we use this process so that there is some meaning when we say that the public are participating in our governance processes? Because so far it is a sham, in my respectful opinion. Evans Ogada, on national security and foreign policy, I think courts can handle, from a judicial review perspective, the same way. But again, you're always dealing with matters where you need some secrecy. So if you're looking at it from a charter perspective also, why do we not figure out how we encourage these people, appreciating that inevitably some level of secrecy in these matters is required, but the secrecy should not be an excuse for unaccountable governance. So what is it that we need to do in administration in those contexts so that they respect the same values of the Constitution? Vincent, when we practice law, when you go to court, they'll tell you, if a judge agrees with you, please don't say anything else. Just nod. So I think now that you agree with me, I am just going to say thank you and I'm going to nod. Thank you very much. But I think we are on the same page. And that is what I have always tried to emphasize, that we must create these barons through legitimate processes. When we say that we have a process of appointing public officers, it must be a process that is transparent, not a process that gives us a veneer of transparency. Because our processes so far, they claim they are transparent, but they are not. If you ask them, for example, what were your rankings? Nobody ever tells you. And why are these, so they'll do it in two phases. When they're doing the interviews, asking sometimes questions that you ask, are these questions really appropriate? It is in the public. When they go to deliberate, it is in private. Why? The difference between a lot of countries that I've seen, and I spent some 6 months in the US at the National Endowment for Democracy trying to compare the administrative law regimes of the United States and Kenya, for example. And what makes the United States different is not its constitution in terms of good governance or democratic governance. What makes the United States different is its administrative law regime. If you pick the administrative law regime of the United States, it will run into volumes for good reason, because that is where the detail of governance is. And they also have what is called Government in the Sunshine Act, so that when these people are meeting, it's the only way we'll get rid of the informalism. So that when they're meeting, we can see, and there are records, so we can go back and say, using access to information laws, we can go back and say, see for ourselves whether whatever it is that they deliberated on and the decisions that they made were in the public interest. Thank you.
The program was meant to end at about 4. Now it's about 4:30. That brings us to the end of the interaction now. I want to welcome the Dean, Faculty of Law, to give vote of thanks here.
Thank you, Vice Chancellor. As the author, James Allen, stated, no duty is more urgent than that of returning thanks. It is therefore my humble duty and pleasure to give this vote of thanks. On behalf of the University of Nairobi community and the Faculty of Law, I wish to sincerely thank the Vice Chancellor for his immense support of this process. Thank you also to our Deputy Vice Chancellors, Academic Affairs, and Research, Innovation, and Enterprise for your support. We especially appreciate the academic registrar and his team for working tirelessly to make this inaugural lecture a success. We are truly grateful. I'd like also to thank some of our guests from the judiciary. I see Professor Retired Judge J.B. Ojwang, retired from the Supreme Court of Kenya, who was my teacher, my mentor, and my dean. Thank you very much for coming. I also see Justice Lenaula and many others. Government officials, we've recognized Ms. Roslyn Jogu, and there may be others in our midst. Academics, legal professionals, thank you so much for coming out to support this process. I wish to congratulate Professor Migai Akech, my colleague and professor in the Faculty of Law, on giving an insightful and thought-provoking inaugural lecture. This is the third inaugural lecture in the Faculty of Law. We were started off by Professor J.B. Ojwang in 1992, and then fast forward to 2013, Professor Patricia Kameri-Mbote gave another inaugural lecture. And we have now, again, fast forward in 2024, have our third inaugural lecture. Thank you, Professor Migai Akech, for giving the university and the wider community the opportunity to engage in discourse in matters relating to the regulation of power. I was fascinated hearing about the possible future of algorithmic decision-making. I think that is definitely food for thought. I'd like to thank the family and friends of Professor Migai Akech. Professor's mother was mentioned. Karibu sana mama. Thank you very much for coming. Thank you to all of you for your support. I have seen also academics from sister universities and other institutions, civil society. Thank you so much for coming. And to the faculty, staff, and students of the University of Nairobi, and I have seen actually some of our former students, thank you very much for being here and even for your active participation during the question and answer session. We appreciate every one of you for coming, and in case I have left out somebody who has played a part in making this lecture a success, I'd like to say asante sana and God bless you. Thank you very much.
And now we shall have a closing prayer by Reverend Hosea Mitei. Thereafter, John Orindi will lead us with the photo session, which is just outside the Gandhi wing.
Permission, allow me to ask all of us to be upstanding for the closing prayer. As we thank God for the blessing of the time that is given to us to reflect together, let's pray. Let the peace of Christ rule in your hearts, since as members of one body, you are called to peace and be thankful. Let the message of Christ dwell among you richly as you teach and admonish one another with all wisdom through psalms, hymns, and songs from the Spirit, singing to God with gratitude in your hearts. And whatever you do, whether in word or deed, do it all in the name of the Lord Jesus, giving thanks to God the Father through him. Let us share in the words of the grace. Now may the grace of our Lord Jesus Christ, and the love of God, and the fellowship of the Holy Spirit be with us now and forevermore. Amen. Go in peace. The Lord bless you.
University haturudi nyuma,
mlango uwazi, wananchi wasome.
Tuwa Nairobi tunayo masomo ya ziada,
malipo ya kiasi mtapata elimu.
Hakuna haja kwenda kusomea ng'ambo,
mlango uwazi, wananchi wasome.
Tuwa Nairobi tunayo masomo malipo ya ziada.
Malipo ya kiasi mtapata elimu.
Hakuna haja kwenda kusomea ng'ambo. University twasonga mbele.